Hello, my name is Michael Tesoro, and I prepared this ACCC video note entitled ACCC 2022 Retrospective, the Highs and the Lows. And what I'll be seeking to do is go through the various outcomes achieved by the ACCC in 2022 and focus on which were the highs and which were the lows. And that's both in terms of policy and enforcement. I think it's fair to say it was a very successful year for the ACCC. There weren't very many lows. There were a couple of significant ones, but generally they had a lot of success on the policy level and on the enforcement level. A bit of background about myself: I'm a competition consumer lawyer, and I've been running my own practice in Sale Consulting for the last 15 years, and I help companies in competition and consumer law matters. I also worked at the ACCC for 15 years in a variety of roles. I was the Director of Enforcement, Director in charge of the City Mergers and Asset Sales Branch, National GST Enforcement Coordinator, and also ran the waterfront cases for the ACCC during the waterfront dispute. So I've got quite a lot of experience at the ACCC from the time I worked there. Outline of the presentation pretty straightforward: month by month analysis followed by some commentary. January was a very quiet year when you look at the media releases. The main issue was a few media releases about rapid antigen pricing. As you probably recall, there was a lot of concerns that companies were charging very high prices for rapid antigen tests, and also there was allegations of breaking up packets of tests and selling them individually. And here the ACCC's main role was to warn companies that any misrepresentations about pricing would be pursued by the ACCC. Also did a pricing analysis to help customers understand the various impacts on pricing, and also to know where prices were likely to be too high, and then referred various cases to other regulators who had specific powers, such as the Australian Federal Police and the TGA. But here is a big issue about the ACCC not having power to prevent price gouging, and something that I think the community doesn't really understand very well. It's been alleged that politicians fuel this misunderstanding by consumers that the ACCC can stop price gouging. Clearly they can draw attention to high prices and, I guess, shame people and companies into not charging high prices, but it doesn't have any specific jurisdiction. And this is an ongoing problem in relation to such things as petrol and gas. February was a busy month, and the main, I guess, low event for the ACCC was the decision by the DPP to withdraw the remaining charges in the banking criminal cartel case. And this arose after a series of very embarrassing events before Justice Michael Wigney of Federal Court, where the indictment was described as being inadequate in many respects and in need of significant revision. And ultimately the DPP must have concluded there was really no prospect of it being able to pursue the case and be successful, so all charges were withdrawn. So that's a bad outcome for everybody, bad outcome for the ACCC, the DPP, and also for the individuals who've been caught up in this criminal cartel case for many years. So ACCC announced a review of this particular case to see what they may have done wrong. Fortunately, it was an internal review. I think they should have had an external review, but that was a pretty bad way to start the year for the ACCC. Then subsequently there was an announcement of the Five Eyes competition authorities focusing on alleged collusion in international trade, and this is primarily in relation to shipping. There's a concern that there might be some collusion going on there. The industry is pretty well known for collusion, and there was an agreement between the US authorities, which is the Department of Justice and the FBI, Canadian authorities, New Zealand, UK and Australia, to work together to, which is sort of somewhat ironic, to identify potential collusion in international trade and to take action. No real actions have been taken at this stage, so there might be something happening in 2023. Then I included the Australian Competition Tribunal decision to refuse the collective bargaining application for miners in the Port of Newcastle. And I included this because it does sort of suggest a bit of a trend, the beginning of a bit of a trend in the way that Justice Michael O'Brien is approaching matters. He has, on a number of occasions, formed a totally different view to the ACCC on particular issues. In this case, formed a totally different view in relation to the need for collective bargaining, which went against obviously the applicant's view and the ACCC view, effectively denied the collective bargaining application on the basis there was no public benefit and no public detriment. So effectively it was a zero-sum gain, so it got rejected. But I think there's a bit of a trend, as you can see, of I guess the ACCC's position on various issues being rejected by Justice O'Brien. A very significant event was the release of a discussion paper seeking comment from stakeholders on potential rules for large digital platforms, and that was an important report. It set out a number of very significant proposed changes and sought comment as to which ones should be pursued. And that report was ultimately issued in September following the consultation period. March was important. It was the announcement of the compliance and enforcement priorities for the ACCC, which is something they've been doing since 2012, and it set out the particular areas that the ACCC will be focusing on. That was released by Rod Sims, and it was also for an 18-month period. So they decided to change the timing of the compliance and enforcement priorities to be in line with the financial year. So this particular one will be in place for 18 months, and then it'll run as per the financial year. Also, the announcement that Jenny Cass-Gottlieb would take over as the new chair of the ACCC, and that's a very good appointment. I think it's an appointment that the government has been seeking to make for a number of years. I think they probably wanted to appoint Gina 10, 15 years ago, but obviously she had to wait till the time was right, and I think she's a very good appointment to take over from Rod Sims. Also, there was an interesting case about patent settlement litigation, and this is a big issue in the US where there have been many different settlements, and here was a proposal by various companies to get authorization for a patent settlement, and so it's the first time the ACCC really called upon to look at these type of arrangements, and its preliminary views were quite negative. So I think it sent a message to the industry that it wouldn't be seeing these particular arrangements as generating much in the way of public benefit. They really are focused on private benefit, and ultimately the parties withdrew the application. Then there was a $12 million penalty against Petty's Ice Cream for anti-competitive exclusive dealing, effectively saying to a distributor that they were only allowed to distribute ice creams of Peter's competitors if they had the written agreement from Peters to do so. So that was seen to be an anti-competitive exclusive dealing arrangement, and a $12 million penalty was found to be appropriate. Then the Cargotec Konecranes merger was cancelled, and I've included that there just to signify that the ACCC did express concerns about quite a number of mergers in 2022. They didn't get a whole lot of profile or publicity, mainly because it was an initial statement of concern by the ACCC, and then the parties worked with ACCC to work out a divestiture proposal. So there was at least 4, maybe 5 divestiture proposals accepted by the ACCC in 2022, which shows that the ACCC's approach to opposing mergers is quite vigorous. They're opposing quite a lot, but the companies are being very commercial in seeking to get the deal over the line by agreeing to sell assets. Now in April there was 3 major events. Firstly, the ACCC and Mazda both decided to appeal the decision in relation to the breach of alleged consumer guarantees. The ACCC established its case in relation to consumer guarantees, and that Mazda had breached those and engaged in misleading conduct in relation to the consumer guarantees, and lost on the unconscionable conduct case. So you've got a situation where Mazda's appealed the misleading, deceptive representations, and the ACCC's appealed the unconscionable conduct allegations. That's going to be a very significant case once it's finally determined if the ACCC win, because all the car manufacturers are doing the same thing. They're seeking to repair vehicles instead of refunding or replacing them, and clearly I think there'll be a very large penalty imposed, and it'll be a real warning shot over the bows of many car companies in Australia that they've got to start complying with their obligations on the consumer guarantee laws. Then Trivago was fined $44.7 million, and this was in relation to the fact that it was actually prioritising different hotels, not on the basis of their price or popularity, but because they had actually paid money to Trivago for the privilege of being ranked higher. This is a significant global case because it was the global business model that Trivago was applying, and so this has led to a number of other regulators having a close look at Trivago. Then there was the report issued by the ACCC as part of its digital platforms review into online marketplaces. It was the first report that didn't identify significant competition problems in the market, namely because the market was fairly unconcentrated and Amazon hadn't really developed the same level of dominance in Australia that it has in other jurisdictions. It's clearly growing at a rapid rate, and maybe down the track it might establish a position of dominance, but for the moment the market is competitive. The report was interesting because it did identify some concerns about self-preferencing and other types of arrangements where vendors can pay money to online marketplaces for the privilege of being given higher profile. May was a pretty quiet month. The main one was obviously the ACCC's case against MasterCard for alleged misuse of market power, and this is an allegation that MasterCard was entering into agreements with large retailers where they would preference MasterCard payment methods above their competitors. So sounds like a pretty vanilla type of misuse of market power case, but there's nothing straightforward about those particular cases, and obviously MasterCard are seeking to contest it. And then also the court, the full federal court, dismissed Viagogo's appeal on both the fact that it engaged in misleading representations and penalty. That was a pretty hopeless appeal, I thought. The case was very clear cut, both in relation to the misleading conduct and the penalty. I think the probably main arguments were that the penalty was too high because Viagogo had been very impacted by COVID and he really couldn't afford to pay such a big penalty, but the full federal court was not impressed with either argument. June was a busy month. I guess Airbnb was taken to court for allegedly misleading Australians about accommodation prices. This was basically showing US prices on their website, but not actually identifying it as US prices. So what people would do in Australia was they book some accommodation thinking they were paying Australian dollars, and they get a bill that was much larger because the price had actually been in US dollars. Now it's a bit surprising. A former client of mine, and I thought did some independent reviews for them in the compliance program, and they seem to be well on top of their compliance obligations, so this came as a bit of a surprise to me. Then they issued the priorities for product safety, and this is another annual event for the ACCC where they make it clear what they're going to be focusing on in relation to product safety, and that's very valuable for business to really know what the focus will be on. And here clearly there's a lot of focus on products for children, button batteries, quad bikes, and for various products. And so it's a clear guideline as to what the ACCC is going to be looking at in the 12 months going forward. Then there was the decision in the Samsung case where there was agreed penalty of 14 million in relation to these water resistance claims. It's sort of funny case because the way it was marketed was clearly that this product was able to go underwater quite easily, and they've got pictures of guys sitting underwater reading their phone, which doesn't sound very safe in my view. But clearly the product was rushed to market, and there was a risk that the charging port would develop water and corrode and the phone could short out. So it really wasn't water resistant. And the penalty was strange because I think the judge struggled to sort of justify a $14 million penalty, and ultimately he started looking at their Samsung's profits as opposed to their sales. So the judgment doesn't make a whole lot of sense in terms of how the penalty was calculated, and I think the fault goes largely on the ACCC. If it's going to put a proposed agreed penalty forward to the court, it's got to have some guidance as to how that number was arrived at. Can't just leave it to the judge to sort of scramble around to make sense of a penalty. Then also in June, the ACCC took Ultratune to court for contempt of court, and this was a failure to comply with various obligations it had undertaken earlier in relation to breaches of the franchising code and Australian consumer law. And it's been a pretty unsatisfactory period of time for Ultratune. They were fined quite a lot of money. There was findings by the judge at first instance that they had actually doctored some documents which they provided to the court, and so there's some real concerns about their whole approach to compliance. So it's going to be interesting to see what sort of penalty, well, firstly, whether the contempt of court is established, and if so, what sort of penalty is imposed. And I think it's clear that ACCC are very keen to pursue contempt of court. They don't just obtain orders and move on. They're very careful to scrutinise that orders are complied with. July was a quiet month. The main thing was the Bank of Queensland agreed to pay a penalty for an alleged breach of the CDR. So the penalty was paid without any admissions. It seemed pretty clear in the press release that they had breached the CDR rules. But this, I think, showed that the ACCC is not going to take a very light-handed approach in relation to the consumer data rights. This is an important right to improve competition in markets, and if various companies who are required to meet obligations under the rules don't comply, the ACCC will seek penalties. And then later on in the year there was a further penalty imposed against another financial institution, and a third company was denied the right to participate in the program because it didn't believe it had the relevant expertise and sophistication. So it's interesting the ACCC is going to be taking this seriously and will be ensuring the companies meet their obligations to implement the rules on time. Also, the ACCC really has ramped up its work on scams. It's doing a lot more work. It's got some money out of the budget to set up a scams sort of centre, and it's providing so much information to consumers on how to avoid scams and ones to watch out for. So this is a real highlight. ACCC has always been good in relation to scam disruption, and it's really enhanced its activities in 2022. August was a very busy month. There were quite a lot of things. The first significant one was its report into the gas industry, and it was a very negative report showing that the market is really not functioning well, that there was likely to be shortfalls in the amount of gas supplied to domestic users, that domestic users were likely to be forced to close down due to the absence of access to gas. Some strange behaviours in relation to the making of offers to domestic suppliers, some pricing anomalies, also a high level of concentration, but also a number of joint venture agreements that have been entered into that weren't approved. So the market is an absolute dog's breakfast, and I don't really know how it was allowed to develop in such a negative way. Then you had the Telstra undertaking in relation to 5G concerns, and I've done a little talk on this one. This is just such a dumb play by Telstra, and they're just so lucky that it was solved or resolved with an undertaking. They really should have been taken to court and fined a vast amount of money, but effectively they implemented a strategy to hinder Optus's rollout of its 5G, and it's quite clear that it was not only a clear strategy to interfere with the 5G rollout, but it went to the very top of the organisation. So these decisions are being made at the board level, and it was just fortunate that the ACCC realised that it could get an undertaking and undo all the steps that Telstra had taken and do that quickly, or commenced legal proceedings which would take many years and thus delay Optus's rollout. So this is quite appalling that a major corporation can engage in such a clear breach of the legislation. Then there was the decision in the Fuji case in relation to unfair contract terms. This is a case that was fought for quite a long period of time, and then Fuji consented, and the court goes through and concludes that there were 38 contract terms in a number of small business contracts which were unfair and thus void. Not a lot of discussion of the law in that case because it's all by consent, so I don't know if it adds to the to the law very much, but it does catalogue a number of terms and conditions which are of concern and which businesses need to withdraw from their agreements or remove from their agreements. Then there was a very significant outcome against Google in relation to location data misrepresentation. It was fined $60 million. That was a very good outcome. I heard that the ACCC really was very happy with that amount. The thing that's somewhat surprising here is that, again, it was an agreed penalty, $60 million, and the court signed off on it, but it really not clear how the court arrived at that amount of money, because what you have is you have the penalty being imposed on the US corporation, not the Australian corporation, who both organisations were sued, and so it's hard to see what $60 million represents of the revenue or profits of Google in the US. So again, it's unsatisfactory, and again, I think the blame goes on the ACCC. If they're going to put forward these penalties, it's got to explain a bit of the reasoning behind how that number was arrived at. Then there was the announcement that Bingo had pleaded guilty to an alleged criminal cartel in relation to the removal of waste, and they are actually a current client, so I'll just make that disclosure. I'm the independent auditor of the Bingo divestiture arising from the Dollar Dump merger, but that was a surprising development out of the blue, that Bingo, which is subsequently to the conduct being acquired by the Macquarie Group, just pleaded guilty to this particular alleged cartel and will be facing a sentencing hearing in early 2023. I've included the CFMEU and Hutchinson case there mainly because it was probably the first case where the court was forced to apply the reasoning from the High Court case in Pattinson, which said that the primary goal, obviously, of civil punitive penalties is to achieve deterrence, and where there's an organisation or a union that has breached the law on many, many occasions, it may be necessary to look at the maximum penalty, because nothing short of that will achieve the outcome of achieving deterrence. So this is a case where the judge did actually impose the maximum penalty on the CFMEU following the reasoning of Pattinson, and it's got big implications for companies like Woolworths, Telstra, and so on, who have been taken to court many times by the ACCC, that they could actually be looking at the maximum penalty being imposed if Pattinson is applied. Then there was a Mercedes case, which wasn't the most significant case, but this was basically a failure by Mercedes to comply with its Takata recall communication plan. But I included it in there because it was significant in the fact that the judge, Middleton, made this conclusion as to the way the penalty provisions work. So the way it works is it's either, at that time, 10%, $10 million, 10% of turnover, or 3 times the benefit. But what he concluded was you actually go from 3 times the benefit to 10% of turnover if there's a benefit. But if there's no benefit, then you don't move to 10% of turnover. So in this particular case, it was agreed there was no actual benefit to Mercedes from its failure to comply. So there was no basis to proceed from 3 times the benefit to 10% of turnover. So what Middleton did, he went back to $10 million, which is very fortunate for Mercedes, because $10 million was a lot lower than 10% of turnover. But that was an interesting finding of the way the legislation worked in situations where there is actually agreed to be no benefit to the company who's been sued. Then in September, there were the first imprisonment or sentencing of individuals for criminal cartel conduct, and this was a very small cartel involving Vietnamese money brokers, and there was a very experienced judge with a lot of experience in criminal law who was presiding over it, and she ultimately decided on a number of sentences but allowed everybody to be released on recognizance. So even though there were sentences imposed up to almost 3 years imprisonment, everybody got a recognizance release. And I think that was probably due to the fact they pleaded guilty and they were small business. But it was a significant development for the ACCC, because a 3-year, up to a 3-year penalty of imprisonment is a significant statement by the court on the seriousness of these particular laws. And then the other significant development in September was Lactalis, which is a major milk processor, was found to have breached a number of revisions of the Dairy Code of Conduct. And that was significant because there hasn't been a lot of strong enforcement of the code, and it did clarify a lot of aspects of the code. It's probably a bit mixed result. A number of results went against Lactalis. It was successful in others, and it's very technical judgment. There are a lot of technical requirements that processors have to comply with, and they had failed to comply with in a particular case. Ultimately, I don't think there'll be a very large penalty imposed in that particular case. October was a very busy month. The first thing was the ACCC announced these internet sweeps and greenwashing, which arose out of its priorities. Also fake online reviews, so reviewed a number of sites to see the prevalence of greenwashing claims, the failure to substantiate claims, and out of that will come a lot of enforcement activity. The ACCC received some new functions in relation to regulating water market conduct, which is a good development, because it'd be effective in the way it does that particular work. Also announced that Delia Rickard, who was the consumer law appointee to the commission, she'd retired and been replaced by Catriona Lowe, who also has a wealth of experience in consumer law. So that's a good appointment. Then there was the announcement that the former Bingo CEO Daniel Tartak had pleaded guilty to aiding and abetting the cartel that I described earlier. Now, that's a significant case because he's a senior exec and he's admitted to engaging in cartel conduct. Obviously, he must think that's the best way to avoid an actual jail term, because if you plead guilty at the earliest opportunity, the cartel didn't last for a long period of time. I think it lasted for a few months. So I guess by pleading guilty, he can most likely avoid going to jail, although that is definitely a possibility, and he'll be facing a sentencing hearing in early 2023. ACCC sued Fitbit. It's had a few run-ins with Fitbit over the years, but it took them to court over statements about faulty devices. So it's an allegation that they breached their consumer law obligations, and that it's going to be an interesting case how that pans out. And then the ACCC received a number of additional responsibilities in the budget. Clearly, it had some additional responsibilities in the water market conduct. There was also some pricing review in relation to childcare facilities, which is a bit unusual, and setting up a scam centre. So it's obviously popular with the government and being given a lot of additional new responsibilities. Fortunately, not a whole lot of money. It really should be given a lot more money given how successful it is. November was busy as well. The major thing here was the decision by the Parliament to introduce these new penalties for breaches of both the Australian consumer law and the competition and consumer law. And so now the way it works will be $50 million, 3 times the benefit, or 30% of the adjusted turnover. And that is by far the biggest penalties anywhere in the world. There was some suggestion that these laws need to be introduced to make them consistent with laws overseas. I don't know if that's quite right. We already had the highest consumer law penalties anywhere in the world, and now they're really vastly beyond any other jurisdiction. But so the way it's going to work is that if you're a company with a turnover of less than about 180 million, you're going to be looking at a maximum penalty for breaching consumer or competition laws of 50 million. If you're over that magic number, then you're looking at either 3 times the benefit or 30% of turnover for the whole period of the conduct. So at the moment, the penalty, the 10%, prior to the change, the 10% applied to the annual turnover of the year that the conduct ceased. So there'd just be 1 year of annual turnover looked at. But under the new changes, if say a cartel agreement has lasted for 3 years, then the turnover for that 3-year period will be added together and times by 30%. So just using a hypothetical, say a company's got a turnover of $200 million, and they've engaged in a cartel for 3 years. That's a $600 million adjusted turnover, and it'd be 30% of that. So as you can imagine, that's going to be a very large number. So those changes have come in. Also, there's significant changes to the unfair contract terms law, both in terms of introducing penalties for breaches and for reducing the thresholds as to what constitutes a small business, and also removing the monetary levels that have to be met to satisfy the definition. But those changes won't be actually implemented till November 2023, so companies have a little bit of time to get the house in order. As I mentioned earlier, the ACCC received some extra responsibility in relation to inquiring into childcare pricing, and it's using the old price surveillance powers. Then the ACCC report was given to government as to the changes that were needed to curb the market power of digital platforms, and it's really a very sophisticated approach. It's focused very much on individualized codes of conduct for different digital services, which is a much more sophisticated approach than, say, has been looked at in other jurisdictions such as the US or in Europe. But it's a very labour intensive one. Obviously the ACCC has to consult with stakeholders and develop specific codes of conduct for each service, and then designate particular digital platforms to be covered by that code. So that's a lot of work, but it's yet to be seen whether the government accepts those recommendations. They've actually put it out for consultation at the moment, Treasury, and probably report the new year. I suspect they're going to accept virtually all of the recommendations that are set out in that report. Then also in November, Alkaloid and its former export manager were sentenced for criminal price fixing cartel, and this was a really hardcore cartel that had gone on for many years. It was a global cartel. It was quite fascinating to read just how extensive it was. Alkaloids and export manager were very active in enforcing compliance with the cartel arrangement, so clearly there was a lot of culpability there. And whilst the company was fined a lot of money and the individual export manager was sentenced, he was allowed to serve the period of imprisonment as an intensive corrections order, and that effectively means he doesn't go to jail. He does community service, 400 hours of community service. And so that was somewhat surprising to me, because it seemed that you couldn't get a more clear-cut, hardcore and damaging cartel than that particular case. And it seems if that particular individual wasn't sentenced to an actual term of imprisonment for that conduct, you just wonder who could be actually sentenced to a real period of imprisonment. And I think the main reason why he may not have got a term imprisonment, maybe his age, he was a bit older, but also he appeared to have a sick wife and an elderly mother who he looked after. So I think maybe those factors were significant in the decision to impose an intensive corrections order rather than actually requiring him to go to jail. Then finally, NBN submitted a special access undertaking to the ACCC that wasn't a total joke, and that's going to be looked at. But previous reports or previous undertakings were withdrawn because they clearly weren't meeting the obligations that people expect of NBN. So finally they were able to submit something that sort of ticked the right boxes. Then in December was a very busy time. You had Uber was fined $21 million for various misrepresentations. And this is a funny case where Justice O'Brien initially said that the penalties were much too high, even though it was by consent. And he's talking about cutting the fines down to much lower amounts, but ultimately he didn't reduce them that much. They went from 26 to 21. But I guess it just shows a bit of a trend here of Justice O'Brien sort of taking a different view to pretty much everybody else in the room. BlueScope was found to have breached the civil cartel provisions along with its general manager Jason Ellis. That judgment took a long time. I think it was Michael O'Brien again. Took a long time to come out. I haven't read it yet. It's very lengthy. I'll read it probably in the new year, but it'll be interesting to see how the penalty provision or penalty phase goes. Then probably one of the big downs for the ACCC in 2022 was the court dismissing the ACCC case against Google, and this related to various privacy settings. And no doubt the ACCC will appeal this case, but the judge is a very sound judge, Justice Yates, and I think his analysis seems somewhat impenetrable, I think, in terms of his conclusion. So whilst ACCC appeals, and I'm not too sure how successful they're going to be in appeal. So that's an unfortunate case for the ACCC to have lost. Then Aussie Skips and its chief executive were charged with alleged cartel, and this is in relation to agreement with Bingo. We're still yet to hear what their disposition will be in relation to the charges, whether they'll contest them or plead guilty. Again, if you contest them, there's a risk you may end up going to jail. If you plead guilty, you've got a strong chance of avoiding being incarcerated as a first offender. Then there was the decision by the ACCC to reject the Telstra TPG regional network deal. This was pretty well expected because, let's face it, ACCC went to court to try and stop TPG and Vodafone from merging, and there was very little doubt that ACCC would not like Telstra and TPG to get together in the regional areas. But this is going to be litigated. It's going to be a big case. It's going to go to the Competition Tribunal, and the ACCC's record in the Competition Tribunal is very poor. So that'll be a big case for 2023. It'll be interesting to see what happens, but you'd have to think that the tribunal may go against ACCC on that one. And then finally, the long-running case involving Retail Food Group was settled, and this was somewhat surprising. Although ACCC had a very good case, whether it decided to settle because the case was going to be dragged on for a long period of time, and customers and former franchisees were going to not obtain any benefit. That might have been the motivation for the settlement, but it's a good outcome. I think there's $10 million worth of waived costs, and there's also payments to various franchisees. So I think it's a good outcome, probably a practical outcome, but hopefully RFG have learnt to improve their behaviour. So that's my summary of the year. It's a lot happened this year, both in terms of policy, legislative changes, digital platforms, great enforcement outcomes, and not very many litigation losses. Clearly the appointment of Gina Cass-Gottlieb is a very good appointment. It's overdue, but I guess it's the right time for her to take over, and since she's taken over, it's been seamless. I think she's agreed with a lot of the positions that Rod Sims had, and so it's a very good appointment. I have a feeling that the level of consultation within the ACCC, given Gina's personality, is going to be enhanced, and that'll obviously make it a better organisation in the sense that she's very consultative, I think. It's a very, very strong year for the ACCC. Had a lot of wins, significant cases, global outcomes, cases that have had impacts around the world, and some great sophisticated thinking on digital platforms, particularly its approach to codes of conduct. I think that's a very sound approach. Very good enforcement outcomes, lots of penalties. Clearly, it hasn't lost very many. Clearly, the big embarrassing loss was probably the decision by the CDPP to drop the banking cartel case, which I thought was quite ill-conceived case. There weren't many other losses. I guess the Google loss at the end of the year sort of ends the year on a bad note for the ACCC, but generally a lot of successful outcomes. And the big factor for 2023 and beyond is the new penalties that came in 10th of November 2022 of $50 million, 3 times the benefit, or 30% of the adjusted turnover. That is something that business have to be very aware of. If you breach the law after the 10th of November 2022, you are looking at incredibly large fines, and the courts are going to be under a lot of pressure to impose those fines. One thing that I did notice at the end of the year is a couple of courts commenting on the poor evidence that was given to the court justifying a agreed penalty. That happened in the Uber case, and also in another case, Justice Mashinsky raised some concerns about that. So I think the ACCC in 2023 has to improve the quality of the evidence that it puts to the court in support of an agreed penalty. And I've been banging on about that for the most of the year, just reading the judgments and realising that the evidence that was given to the court was just insignificant. They are treating the courts a bit like a rubber stamp, and they're not going to be accepting poor evidence going forward. So it's going to be an exciting year in 2023. I think the ACCC had a stellar year, and it'll be really interesting to see if they can continue the successes of 2022. I think the big cases that they've got to be a little bit concerned about going forward, clearly the Telstra TPG deal going to the tribunal. If that is determined in 2023, that could be quite a big loss for them. And the other one that's going to be maybe a difficult case to succeed in, maybe the MasterCard Section 46 case. So that's all I had. If you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.